Good afternoon. I'm Angelica Spanos, and this is the Law and Crime Report, where we are diving into true crime and all legal headlines making headlines today. First, we'll get started with a preview to Monday. We are going to be covering a live hearing for Justin Ross Harris. For more than 4 years ago, Harris was sentenced to life in prison without parole for the murder of his 22-month-old son, Cooper Harris. Cooper died after being left in the back seat of his father's car for over 7 hours while his father worked at a Home Depot office. Harris is now on a quest for a new trial. Him and his attorneys will appear in a 3-day hearing that will be heard virtually. We're going to revisit his trial and go back and look at Harris parking his car with his son inside.
Okay. Looking here at 9/25/17, is there anything in particular to this video that you pulled where we see the suspect's car coming into the video?
It should be the top left.
Is that it right there?
I believe so. If you can hit play, I could see it a little clearer.
Okay. That time is 9/25/17, correct?
Yes.
Okay. Is that it?
That is.
Okay. Just going to continue and let it play. Okay. Now the car's come to a complete stop on this video. What is the time? Is it 9:25:39?
9:25:39 a.m.
Okay. All right. Now I'm going to go ahead and start the video back again. Okay, I've paused it again. Do we see at this point it's 9:25:56? Do you see the door start to open?
I do.
So Harris's attorneys filed a motion for a new trial back in 2017. They said that the court made a number of errors that prevented Harris from getting a fair trial. Some of those errors, they say, were the fact that Harris was tried for separate charges related to allegedly sending explicit photos to a minor. With us today to break all of this down, we have Imran Ansari, Law and Crime legal analyst, as well as Bernarda Villalona, former senior homicide prosecutor. Thank you both for joining us today. Coming out to you first, Imran, this quest that Harris is making to try to get a new trial, do you think he has grounds here?
Well, I think he does have grounds because of the argument that his attorneys are making that these other charges were presented during the same trial and to the same jury. Those are charges that would tend, as the defense is arguing, to prejudice the defendant. He was certain charges that were presented to that jury, Angelica, were the charges associated with sending explicit images to a minor. Now, there were the charges that were related to the unfortunate death and passing of his son, which were malice murder and all the lesser included. However, the jury also heard these other charges related to the quote-unquote sexting to a minor. Those are charges that, when coupled with the murder charges, could arguably prejudice this defendant before the jury. So if the defense really hones in on that, hones in the potential prejudice that he experienced because of these charges being coupled with those murder charges, then I think that he may have a prevailing argument to get a new trial.
All right, we will wait and see. That is going to be live starting on Monday. Bernarda, you know, with this type of case and the nature of this with a child, obviously, do you think that we'll get a ruling from the judge there immediately, or is this something that could take some time?
So it can take some time because obviously the result, the end game of what happens with that decision is going to play a huge role on the trial itself. However, being that the trial is already set to start, I believe that maybe the judge will probably take a day or so to reach a ruling because they do want to move the case along.
All right. And what are your thoughts on Harris's defense here with him not getting a fair trial. Do you think that he has grounds there?
I definitely think that he has grounds there because the reality, Angelica, everyone is entitled to a fair trial. You have a constitutional right to a fair trial. Here, Harris did not have a fair trial. And the main reason why he didn't have a fair trial is because they coupled this other allegation having to deal with the photographs of these kids that has nothing to do with the death of his son. Those charges should have been charged completely separate and apart from the homicide charges. There's no relation to the two events. And because there's no relation to the two events, I believe that the jury, their mind was cluttered and clouded by the negative connotations of that other charge. And being that the case, I don't believe that he got a fair trial.
All right, Bernarda, Imran, thank you so much. Again, that trial hearing will be live on Monday here on Law and Crime. We're going to switch gears now. We have new updates on Ghislaine Maxwell's indictment. Maxwell, who is known to be the madam of Jeffrey Epstein, has been held since her July arrest on charges that she procured teenage girls for Epstein to abuse in the mid-90s. Well, the socialite has pleaded not guilty and is preparing for a trial next July. One of the three alleged victims in the indictment is now attempting to dismiss her civil lawsuit against Maxwell and the Epstein estate. But attorneys for Maxwell are objecting, saying that they first need to be provided with a copy of a confidential settlement agreement that the alleged victim received from the estate. The alleged victim, Annie Farmer, is 41 years old now. She's identified as victim number 2 in the criminal case, and she will likely be called as a witness if Maxwell's case does go to trial next summer. Let's go back and listen to William Sweeney, the assistant director of the FBI, announcing Maxwell's arrest.
Almost 1 year ago, when our offices stood before you and announced the arrest of Jeffrey Epstein, I stated that preserving the innocence of children is among the most important responsibilities we carry as adults. Too often, adults in our society have turned a blind eye to the type of criminal behavior that we announced back then and announce again today. The villains in these outrageous crimes are the adult perpetrators, not the youth, who are our neighbors, our students, vulnerable foster children, and teens seeking support. Today, we announce the arrest of one of the villains in this investigation. Early this morning, Ghislaine Maxwell was arrested in Bradford, New Hampshire, by FBI special agents and NYPD detectives from the FBI NYPD Crimes Against Children Task Force. Our team from New York was assisted by special agents assigned to our Boston, Newark, New Haven, and Albany field offices. We've been discreetly keeping tabs on Maxwell's whereabouts as we worked this investigation, and more recently we learned she had slithered away to a gorgeous property in New Hampshire, continuing to live a life of privilege while her victims live with the trauma inflicted upon them years ago. We moved when we were ready, and Ms. Maxwell was arrested without incident. Like Epstein, Ms. Maxwell chose to blatantly disregard the law and her responsibility as an adult, using whatever means she had at her disposal to lure vulnerable youth into behavior they should never have been exposed and which creates lasting harm. We allege that from at least 1994 through at least 1997, Ms. Maxwell assisted Jeffrey Epstein's abuse of minor girls by helping to recruit, entice, groom, and abuse children under the age of 18.
All right, I want to talk about this with our guests again here today. Imran, coming out to you first. Why is Maxwell's attorneys, why are they dismissing and putting, kind of dropping the fact that the victim here wants to dismiss this civil lawsuit? Why would they do that?
So, Angelica, the civil lawsuit, and particularly the settlement agreement, is a vehicle for discovery, if you will, that could be used in the defense in the criminal case. You have Annie Farmer, who had brought a claim against Ghislaine Maxwell along with the Epstein estate, who is now taking advantage of this fund. There was a fund, a victims fund that has been set up. She's going to be getting a settlement from that fund, and now she is looking to dismiss with prejudice, I would imagine, the lawsuit against the Epstein estate and Ghislaine Maxwell. Ghislaine Maxwell's attorneys are saying, no, before you do that, we want to see this settlement agreement. We want to see some discovery, some parameters in that case. So you would think that, okay, you have a plaintiff ready to dismiss a claim against the defendant would say, hey, that's great, I'm ready to go, dismiss the case. But no, in this case, they want to see that settlement agreement. You know why, Angelica? Because they could use that information during the criminal trial. If Annie Farmer is on the stand, and we know that she's victim too, they could cross-examine her. They could say, listen, you got a settlement in a civil case. You received X, Y, and Z sum of money. And they could sort of spin this defense, this narrative, that perhaps this was motivated not by being a victim of a crime, but by money, by a civil pursuit. So that's why I think that Ghislaine Maxwell's attorneys are looking to say, no, before you dismiss this case, we want to see that settlement agreement, and we want to see the parameters and some information in that case.
All right, and we know that right now she's still looking to be released on bail. Does this have anything to do with that, or does this play into that in any way, Bernarda?
So her looking to be released on bail, remember that at the last bail argument that this victim, this complainant, did offer some information at that bail hearing requesting that Ghislaine Maxwell not be released because she is a terror. She is a threat to society, giving her pimping out pretty much young girls. So she did testify in that effect at that hearing. Now, in terms of what the defense can actually do is spin it and say that, look, this same person that is alleging that I committed these acts is now requesting to dismiss the civil suit. But separate and apart, these are two different things. Obviously, the disclosure of the settlement agreement is going to be huge for Ghislaine Maxwell's defense, because in any case, the jury has to decide the credibility of each and every witness. So in judging the credibility of this complainant, of this victim, a huge part of discrediting her is that she entered into an agreement and thus looking for money, and it wasn't about something actually happening to her. So this is going to be crucial for her defense at trial, but doesn't really affect the bail argument.
All right, Bernarda, Imran, thank you both. We will be keeping our eye on that as new developments happen with the Ghislaine Maxwell indictment. We got to take our first break right now at the Law and Crime Report. Stay with us, plenty more after this. And welcome back to the Law and Crime Report. In Ohio, the Supreme Court upheld the death penalty for serial killer SHAWN GRATE. GRATE was convicted in 2018 of aggravated murder and kidnapping in the deaths of Elizabeth Griffith and Stacey Stanley. He later pleaded guilty to murders of 3 other women. This is after trying to appeal his charges connected to the 2018 convictions. A judge now says that there is no reversible error in the proceedings. GRATE argued that his defense lawyers were deficient for not asking to change the venue for his trial. He also complained about 2 jurors who said that they recognized some of his victims. And additionally, he said that his defense counsel made no attempt to limit media access and were ineffective for withdrawing his plea of not guilty by reason of insanity. The Ohio Supreme Court did not agree, though, said that the death sentence was appropriate and proportionate to the other kidnapping and murders done by GRATE. We're going to go back now and listen to one of the most compelling things in his trial that happened. This was the 911 call from a woman that he was holding captive. This was not one of the victims in his 2018 trial, but a third woman who was actually able to escape because of this call. Let's listen.
John Green.
You said John Green?
SHAWN GRATE.
Where's she at now?
Asleep.
Where's she sleeping at?
In the bedroom.
In what bedroom?
There's 2 houses right by the laundry street. And it's in one of those houses.
But you're at the laundromat?
No, I'm in the bedroom with them.
This is not a whodunit case. This is a he did it case. The discovery of this defendant's crimes began Tuesday, September 13th, 2016. At 6:48 a.m., a woman called 911 from 363 Covert Court in the city of Ashland. 363 Covert Court is a yellow two-story house sitting just a couple of feet from an identical-looking structure. Both houses are across the street from the laundromat on 4th Street. These houses are supposed to be vacant. At the time, they were owned by Pump House Ministries, and other than the laundromat, neither house, with the exception of the other, is near anything. The area is desolate, lonely, and despite being out in the open, in a way secluded. Although 363 Covert Court was supposed to be a vacant house, it was very much occupied in August and early September of 2016. The defendant had chosen to take up residence, and although he had the run of its basement and 2 stories, he chose to consolidate his assets in a room just off the kitchen, separated from the rest of the house by a blanket affixed to the wall. He had scouted the house. He had watched it for a couple of days. He wanted to be sure no one would mind if he moved in.
All right, so we heard that 911 call and now some of the prosecution's opening statements from that trial. Imran Ansari with us here today, as well as Bernarda Villalona. Imran, what do you think of the Supreme Court? They're saying that the death penalty here was appropriate. You agree?
Yeah, Angelica, I think the opinion is spot on, where it discusses that the overwhelming amount of evidence that tended to prove his guilt was enough to succumb, or surpass, I should say, the defense argument that there was some ineffective assistance of counsel and that he didn't receive a fair trial, to an amount that it would require a reversal of that conviction and of the imposition of the death penalty. So I think that the overwhelming amount of evidence, I agree with that assessment, would override any ineffective assistance of counsel claim. But what was really particularly interesting, Angelica, is that the judge did take an opportunity to sort of throw a jab at his prior counsel, and the judge did say that there was a departure, if you will, and a misstep by his counsel, where they failed to present the psychiatric evidence that would have mitigated on the capital case, meaning the psychiatric evidence that may have tended to mitigate the likelihood of him receiving the death penalty. But regardless, the court found that the overwhelming amount of evidence still was enough to uphold the conviction and also the imposition of the death penalty.
All right. And, with something like this, which obviously was horrific in its nature, and, that 911 call alone just being such a strong piece of evidence here that ended up convicting him, Bernarda, what do you think of that, the nature of this really affecting the fact that he did get the death penalty?
So, Angelica, when you look at the majority of inmates that are actually on death row around the country, you rarely ever see a case where one of the victims are actually alive. So this case is much different than the majority of cases around the country of those that are facing the death penalty or actually on death row, that you have a live victim that was able to testify as to what she went through, what she actually observed, what she felt, the horror that she went through. So I think that definitely had a huge role in the jury determining that this man should face the death penalty. And that is what makes this case stand out of all the cases around the country. And it was crucial and devastating to the conviction and the ultimate issuance of the death penalty for this man.
All right, we're going to move on. We want to listen to SHAWN GRATE actually pleading guilty. Let's listen.
You've heard the terms of the plea agreement. It's not really a negotiated plea, but basically you're at this point indicating a willingness to withdraw your former plea of not guilty to counts 4, 5, 6, 11, the specification of count 11, 13, 14, 15, the two specifications to 15, count 16, the specification of count 16, count 17, the specification of count 17, count 18, the specification to count 18, and counts 19, 20, 21, 22, and 23, and to enter pleas of guilty to those charges today. Is that correct, Mr. Grate? Mr. Grate, did you have a discussion with your attorneys about the timing of deciding to do this today, since a lot of these charges relate to a specific individual that is irrelevant to the other two in this case? Okay, and you're aware that this is something that could have happened before this trial commenced, and evidence that may not be relevant to the remaining charges would have been produced?
I wouldn't be talking about it.
Okay. And what made you decide today, at this point, after all that evidence was in, that now you did want to enter a plea to these specific charges?
All right, so there you have SHAWN GRATE pleading guilty to the murders. He was dubbed serial killer. We know that he pleaded guilty to murders of 3 other women. This is on top of the other two victims in this. So when you have something like this unfolding and you have a death penalty conviction here, Imran, what does this mean when someone like Grate then goes to try to get this reversed? Do you think people are just like outraged of how he has even the thought to do this? Because he did plead guilty.
Right, Angelica, he not only pled guilty, but he pled guilty to some egregiously heinous crimes. So I think there would be outrage when the public would be reading these news stories, hearing us talk right now, when they see Grate now attempting to reverse what he willingly, knowingly, and voluntarily, arguably, entered into. So is it outrageous that he's now coming to court and looking to reverse what he did? Well, his argument is that he had ineffective assistance of counsel. So he's basically saying that when he did enter these pleas, when he did sit there for the capital portion of this case and the death penalty was imposed, his attorneys were not doing what they were supposed to do. And perhaps if he was guided accordingly, he would have done something else, made different decisions. But yes, I mean, you would look at the facts of this case and you're just outraged. And I'm sure the public there in Ohio is likewise outraged when they're saying, looking at this going on in court and saying, okay, now he's back and he's looking to reverse what he arguably entered into knowingly and voluntarily.
Right, absolutely. It'll be definitely, I'm sure the families of the victims here could not believe that he did that. So again, the Ohio Supreme Court upholding the death penalty for SHAWN GRATE. We got to take a break right now in Law and Crime. When we come back, plenty more of today's top legal headlines. Stay with us. And welcome back. A new law adding protection for judges in New Jersey was just signed. Daniel's law, named for Judge Esther Salas's son, will keep judges' home addresses and numbers private. This is part of a new law that was pushed for a judge who lost her son during a deadly ambush attack at her home. The bipartisan legislation will make it a crime to publish the addresses and telephone information of judges and their families online. I want to talk about this now with our guests, Imran Ansari, as well as Bernarda Villalona. Bernarda, this is obviously a good law coming to be signed right now, but sadly, this is coming to light after a very unfortunate situation.
Unfortunately, it took such a tragedy like this to take place for the government and for the world to take notice that the publication of the addresses and contact information from judges and prosecutors could lead to a tragic incident like this. So Angelica, you know, I was a prosecutor for 16 years. 10 of those years, I worked and prosecuted homicide cases. And I can't tell you the numerous amount of times where my safety and the safety of others would put in jeopardy from those that were looking to cause harm or try to stop us from prosecuting their loved one for killing someone. It's something that lingers in your head every day as you walk and go to court as a prosecutor when you're just trying to do your job. So I love that this finally came about, and I'm hoping that the rest of the country does follow suit.
All right. And Imran, what are your thoughts on this?
Yeah, Angelica, I mean, it's really sort of a no-brainer here that when you have public officials such as judges, prosecutors doing work which may, irk people out there in the public, may get defendants and their families upset with them, that this information would be kept private. Of course, we want an open forum when we deal with our government officials, whether it be judges, politicians, or prosecutors. But this is the sort of personal information that you really would expect to be kept private, especially because judges and prosecutors and law enforcement are dealing with such sensitive and controversial subjects and violent individuals on a daily basis. So I think that the law is well placed. It's thankfully it's in place now, and hopefully across the country, those states that don't have this will be following suit. Because you want judges and prosecutors, law enforcement to go about their jobs without this in the back of their mind. You want them to make the decisions appropriate in order for justice to happen, and not be afraid that if they make a decision on the bench or they make a decision to prosecute or arrest, that they're going to have some sort of retribution both for themselves or their family. You want them to have a clear mind in order to do their job properly. So I think that this law, it's well placed, and thankfully it's in the books now.
All right, Imran, Bernarda, thank you both. We're going to switch gears right now. Christopher Otero Rivera and his father, Angel Rivera, are facing murder charges in the death of Otero Rivera's estranged wife, Nicole Montalvo. She disappeared after dropping their son off at the Rivera's home in October of 2019. Her body was later found dismembered and buried on 2 properties owned by the Rivera family. Well, now their attorneys are arguing that evidence obtained in early search warrants should be thrown out because they say that it was unlawfully collected. In a hearing this week, the defense said that they don't believe the warrants gave them authority to search underneath the earth. Let's listen.
Defense, I think we have laid out. I know we put out a lot. We called in a lot of witnesses back in October, and there was a point to bring in all those witnesses. All those witnesses, while they were here for quite some time, there was 1 or 2 points that kind of come into play when we think about Franks and the omissions. We believe that we've established that the omissions I'm going to lay out were material, and whether it was intentional or just a reckless disregard for the truth, law enforcement laid out their affidavit in a way that deceived Judge Clark about what they had and why they were entitled to a search warrant of the Rivera family. The first point is the searches at Hickson. When they wrote their affidavit, they never discussed what had happened prior to them requesting the search warrant. What we know is that on the 23rd, there were some issues about no one had talked to Nicole, no one had seen Nicole. And the first officer to get over to the Rivera property was Deputy Deco. He talks to Mr. Rivera at 9:30 in the morning. He leaves from there, gets a call from the state attorney's investigator to get back over to the Hickson property because not only are they going to be there, but they're going to send the probation officers over there. Now, I know the state's going to argue like, hey, this was not a warrantless search And perhaps it wasn't your standard search because we know what we were dealing with. But you had 5 officers that go into the Hickson property. Ms. Witherspoon testified, and I believe that she was reluctant to say what she needed to say, and I think we know why. But in any event, what we did get out was the fact that there were 5 people there. She went into the home. They spread out through the home. Whether they didn't take pictures or open drawers, they were not looking for little pieces of evidence. What they were looking for was Nicole Montalvo at the residence? Was her car at the residence? Whether you want to call it a warrantless search or not, they were there. And what they came out of the residence with was there was no signs of Nicole Montalvo. There was no vehicle of Nicole Montalvo. It's not what we learned later. It's what they knew at the time. And so I will continue to go back to that point because that's what we have to look at for purposes of whether they have probable cause for the search warrant. What did they know at the time? At the time, all they knew was she was there, she left, and she texted Mr. Rivera's phone 2 hours later. At that point, they had no reason not to believe Mr. Rivera. So armed with that, they still keep Deputy Deckel at the premises, and he's there for 24 hours, or let me not misrepresent. The Osceola County Sheriff's Office is there for a number of hours until they execute the warrant the next day. That same day on the 23rd, Detective Miller and Detective Sastry, they go into the family home. The Riveras welcome them into the home. They interview Mr. Rivera, Senior Rivera. They interview Christopher Otero, and they interview Wanda Rivera. That interview led to no information that Nicole was there, her car being there. They basically gave them whatever they want. Detective Miller said he didn't see anything. He didn't search the property, but he didn't see anything that caused him any concern. That was that. That has been omitted from the first search warrant. And I'll go into why that's important. The second part was, in the search warrant, they talk about the fact that Christopher Rivera was on community control. Because when you look at the first search warrant, it's not about Angel Rivera, it's not about Wanda Rivera. We are focusing on, or at least Osceola County Sheriff, they're focusing on Christopher Otero. So this is from a missing person investigation to Mr. Otero. In his affidavit, he says that he details the information I've already provided, and then he starts talking about Christopher and Nicole, how they were separated, and he's living with his parents. And some research he did revealed that he was on probation, community control, house arrest, and that there was an active injunction.
All right, so that was defense there making their arguments that a lot of the evidence obtained here was not obtained lawfully. They're talking about cell phone data as well as warrants and other information that wasn't included in some of these affidavits. So Bernarda, when you hear this and when you see the defense trying to make this claim, what is your reaction?
Well, Angelica, every defendant has their constitutional right to dispute whether any search of their property or their items was lawfully done. So obviously, if they are able to get this suppressed, get this illegally seized evidence suppressed, then it would severely weaken the case of the prosecution. So it is crucial for the defendants to actually litigate this kind of motion and to go very hard in litigating this kind of motion, because it will have tremendous impact on the strength of the case of the prosecution. So if the prosecution were to lose all of this evidence, I'm not sure whether they even will be able to go forward with the case, but for the very least, they probably will not be able to prove the defendant's guilt beyond a reasonable doubt.
All right, and when you think about the fact that this was a dead woman, how would it be that the officers, wouldn't they have to have acted in this case? Like, this is not a small crime that we're talking about.
So, of course, the police would have to have acted based on all the information that they had at hand. However, the acting of the police is still guided by the constitutional rights of every individual in this country. So, but what the prosecution can do is argue that there was exigent circumstances, and exigent circumstances would allow them to actually go onto the property if they feel that the evidence that would have been there would have been destroyed. So it still allows them to act. However, it will be up to the judge to determine whether the police rightfully acted given the totality of the circumstances.
All right, Bernarda, thank you. We're going to talk more about this after the break. Stay with us here on Law and Crime. And welcome back to the Law and Crime Report. We have more defense closing statements from Christopher Artero Rivera's hearing. This is about them trying to say that obtaining the search warrants to search his property was done incorrectly, especially when his wife was still just listed as a missing person. Let's listen.
That they had a prior domestic violence situation, and that was that. What he failed to include was that he was also not just house arrest, he was on community control level 2. Why is that important? Because what he had on him was a GPS. And I'll tie that into the next omission. He had a GPS, but what Detective Human does is just indicate he's on community control house arrest. The next thing he fails to, what he omits from the affidavit was the fact that about 2 hours before he submits his affidavit for a search warrant, he fails to include that he locates Nicole Montalvo's vehicle. And where he finds that vehicle is at Big Sky. And why is that relevant? That's relevant because Big Sky is 8 to 10 miles away from the Hickson property. And I think what that does is if Judge Clark was provided with that information, she may have paused. And she may have paused because what they are suggesting in the affidavit is this. Nicole Montalvo drove to Hickson and she never left. Nicole's phone is at Hickson and is still there. But Nicole, and therefore she has been kidnapped by Christopher Otero. And the reason why the omission is this, because Judge Clark may have paused and said, well, wait a minute. If Mr. Otero is your suspect and he's on a GPS and he has not been violated, because that was another point. ASA Daniel Pinnell knew from the get that Mr. Otero had never left the premises. He was never where he wasn't supposed to be. So there was absolutely no violations. So then the question becomes, well, if Mr. Otero is your suspect and Nicole Montalvo drove her car to that place and never left, how is it that that car ends up in Big Sky, yet Mr. Otero is still at Hickson and never left? That was deceptive to Judge Clark. They did not give her that information because they knew she may have paused, she may have questioned, wait a minute, you need to go back and investigate a little more. Because you can't think about Angel Rivera, whether he was involved at that moment, or Wanda Rivera. This is about the only person that they identify in this affidavit is Christopher Otero and his relationship with Ms. Montalvo.
All right, so more there from the defense. I want to get your opinion on this, Imran. So now that we've heard what the defense is saying here about these warrants and about the way that they were gone about, what are your thoughts on them trying to make this argument? Do you think that this will be successful?
Well, Angelica, this is classic Fourth Amendment search and seizure law. They're looking to attack the probable cause upon which these search warrants were issued. They're talking about deception. They're talking about misconstruing facts or leaving out certain facts in the affidavits that were presented to the judge in order to get this search warrant. And that's what we call looking to establish the fruit of the poisonous tree argument. That's saying that anything that was part of this poisonous tree, and that would be the illegal or unlawful search warrants that were improperly gotten by the prosecution and law enforcement, if you will, would the fruit, that would be the evidence coming from this tree, would not be able to be used at trial because it's a fruit of the poisonous tree, meaning that the warrant from inception was unlawful, was improperly gotten, and now you can't use that evidence. And as Bernarda had said before the break, that is the best way to sort of cut down that tree, to undercut the prosecution, and take away evidence that the prosecution may be relying on to prove their case beyond a reasonable doubt at trial. As a defense attorney, if you're able to suppress evidence based on search and seizure law, based on violations of the Fourth Amendment, on an improperly gained warrant, well, you know what? You're putting yourself at an advantage, and you're undercutting and cutting out the prosecution case and their ability to prove their case beyond a reasonable doubt. And that's what they're trying to do here. They're trying to take away the prosecution's evidence by getting it suppressed. And if they're able to do that, Angelica, well, I think that they're going to be able to really put on a better defense for their clients.
All right, Imran, thank you so much. We're going to switch gears right now. We want to talk about our last topic of the show today. There are new developments with the murder of 59-year-old journalist Jamal Khashoggi. He was killed in Istanbul in the Saudi consulate last October. Well, now the CIA, it's determined that they cannot block video that was acknowledged by President Trump being exposed or being shown or exposed. A tape of him entering the consulate was found, and President Trump had alluded that there could even be a tape of his actual murder. Because it was acknowledged that now the CIA cannot block that information. Now, after being pushed for more details about his death and for those for the investigation to be released, the CIA now says that it cannot refuse to disclose whether or not they have this tape of the murder. The tape's existence was, again, acknowledged by Trump publicly, as well as Vice President Mike Pence. So this does mark a small victory for the Open Society Justice Initiative, which was one of the groups that was fighting for the transparency surrounding Khashoggi's death and his investigation. My question here for you all is whether or not that, because it was simply acknowledged by the president, does that mean that it has to be released now? Imran, I'll come to you first.
Well, Judge Paul Engelmeyer of the SDNY, a very cautious and very careful judge when rendering decisions, has issued this decision, and it's basically saying, listen, there's been acknowledgement by the executive branch, by President Trump and Vice President Pence and CIA Director Gina Haspel, that there's evidence, possibly a video, and most likely a report regarding Khashoggi's death and an investigation into that. So that's giving a good faith basis for this motion, for this action to come forth in the SDNY, and for this Open Justice Initiative to seek transparency. And there's a good faith basis to seek these documents, and the CIA really can't say that they don't exist, or they're going to have to come forward with some more evidence, or at least some sort of proof that it doesn't exist. So I think it is a victory for transparency, and there's an acknowledgement here, and perhaps we're going to see this investigation, and perhaps we're going to see this tape come to public light.
All right. And if this tape were to be released, Bernarda, this would be huge, because there's been a lot of controversy surrounding this, a lot of people wanting to know what exactly happened. And as of right now, we don't really know what exactly happened inside that consulate. There's many speculations. There's a lot of different ideas and theories floating around. But if this tape's released, it would be game changing, right?
Definitely, because the videotape is going to speak for itself. So the truth will be revealed to the public of what actually took place in this embassy. There is no hiding of the truth when there is videotape evidence of what actually transpired. You're not able to spin it in any certain way because the video speaks for itself. Without the video, sure, people could have put out there, this is what could have happened, or this would have may happen. But with the video now being in existence, and if it were to be revealed to the country for us to see, then it speaks for itself. There's no way you can spin it.
Absolutely. And, you know, one of the things that was talked about was the fact that Khashoggi was critical of the Saudi government and he entered that consulate. So there was a motive, if you will. He was a journalist writing about this. So that was one of the theories here. So again, as Bernarda said, the tape would speak for itself and just be absolutely crucial in giving us answers and transparency in Khashoggi's death. That is all for today on the Law&Crime Report. Coming up, we have more of our regular scheduled programming. Imran, Ansari, Bernarda, Villalona, thank you.